Well, hello, Robo Lawyer. We're back, and this time we've got to talk about the defences to defamation, because last time we talked about defamation and we discussed what amounted to defamatory communications and different defamatory meanings like the imputations. So this week we examined the remedies for defamation and also the defences which a prospective defendant may be able to raise when faced with an action for defamation. Now, generally the remedies for defamation have been an award of damages. And in the lecture we talked about the different sorts of damages which could be awarded depending on the extent of the harm done. Now, under our new defamation law, it becomes interesting because there is a cap on the damages which can be awarded. So that makes it less lucrative for people to go seeking remedies in defamation. We also look at the other remedies which may be available, for example an injunction to stop the publication of defamatory material. Right. And we look at other remedies like apology, offer of amends. What's that, pencil dog? What's an offer of amends? Well, that's where the defendant offers to do something for the plaintiff to clarify the matter. It may include giving the plaintiff a right of reply in the publication and subsequently, and quite often that's what the plaintiff wants, rather than sort of court hearings a couple of years later where the issue's no longer topical at the time. So those remedies are fairly much immediate. That's the important thing there, the immediacy of the remedies. Now, under the Uniform Defamation Law, that's right, Robo Lawyer, it's across all states and territories of Australia. There are a number of defences, so they're all pretty much, they are the same. And it's interesting because some of them have been widened. For example, now, if you able to establish the truth of the defamatory statement, then that acts as a defence, the truth of those facts which the person complains of. However, the other thing is that sometimes I guess there are a number of imputations in a defamatory statement. Now, I guess the example there is recently a university was described in a newspaper report as being a bottom feeder. Now, that's a fairly general sort of statement, but a lot of people felt it was defamatory, and that was because it carried a lot of imputations. Now, in seeking to defend that, the defendant would have to establish the truth of all of those different imputations. That's right, Angel. They're all the defamatory meanings that the people receiving the communication might read into that communication. So rather than being fairly factual with the description, using a term like that gave rise to a whole lot of imputations. Now, there are other defences as well as the truth. There's contextual truth, where it's the substance of the allegations true, even though there are minor details which may not actually be true. But the harm to the reputation is not enhanced because the true facts have sufficiently damaged the reputation anyway. And we've got the privileges, the absolute privilege, the qualified privilege, those sorts of things. Triviality, innocent dissemination. So it's really, there's a range of defences available there, and I think it's important that we consider them all. Now, when you're dealing with a defamation question, I guess the thing is to consider what possible defences. You don't have to make a definite decision, that's for the court to decide anyway. But the court won't decide on an issue unless it's actually raised. So it's important to put those matters before the court. Yes, that's it. And then we talked about other things like criminal defamation, where it's relatively rare these days, but the standard of proof is beyond reasonable doubt there, as opposed to the civil standard. And quite often you need permission from the Attorney General, Director of Public Prosecutions before that goes ahead. And the other one is the injurious falsehood, and that's the question where someone said something bad about a person in trade or commerce. Now, remember, under the new defamation law, a lot of corporations are precluded from commencing an action in defamation. They may be able to bring the action of injurious falsehood, but in actual fact, what happens is under what's that rub I'm hearing? Section 52 of the Trade Practices Act. How would you know about something like that? Yes, they can bring an action for misleading and deceptive conduct. Anyway, so that's what the second of the lectures in defamation is about. Important ideas, and you see them in the media raised quite often. I think we'll say goodbye for the moment, won't we, Pope? We say goodbye. Now, I've got to go over and turn this thing off because it's a different camera I'm using today. It's not controlled by the mouse, so we'll have to see how that goes. I'm going to turn it off. So you say goodbye, everyone. You're all waving. We're all waving. Okay, you're going to say goodbye. Here they are. Can you see them all? Look there. There they go. Goodbye.